Motion limine 66, which concerns Mr. Lamar, Rich Homie Quan, and neither side really should be able to say. It seems that the defense wants to bar the state from being able to say, the defense didn't call this witness at trial, which obviously they concede they have no right to do and say they have no intention of doing, and they would not be permitted to do such. But at the kind of flip side of the same coin, the defense seems to maybe be suggesting that they would like to to present that the state could have but did not call that witness. And I would not permit that either, because we're clearly nowhere near, unfortunately, the end of the state's case. And obviously, Mr. Lamar has now passed, and so we don't know whether they would have called that witness or not. So I wouldn't permit the defense to make that kind of a presentation either. So I trust that everybody understands what they would not be permitted to do. And then we have, yes, sir.
Speak to that for a moment?
Yeah.
Good day, Your Honor, and good day, everyone.
Good morning.
So, I understand your ruling, obviously, abides by it, but what I'd like the record then to show, if you don't find this to be changing, the state sent us lists of witnesses on a short list that they were going to call Mr. Lamar, who's a performer known as Rich Homie Quan. This was well before September 5, 2024, when he, God forbid, passed unexpectedly. So, to me, and the state has put in evidence over objection that starting in the fall of 2014, Mr. Lamar and Jeffrey Williams don't get along, and Mr. Lamar is with Mr. Donovan Thomas, who doesn't get along with Jeffrey Williams. And it's all, to me, it's all made up. It's not supported. Obviously, the jury can make that determination. But I think that it is important that the state, in writing, put the predecessor court, as well as Mr. Williams et al., on notice that they were going to call Mr. Lamar. They filed their service of a subpoena, and they don't call him to support this, supposed beef. And I can't do anything about his prior statements now because it would be frivolous under 24-8-807, which is rarely used, it's frowned upon, and it has to have the same guarantees as a dying declaration or something. It's not like that. He gave interviews throughout all the years talking about his close relationship with Jeffrey Williams. And if you let that in, that's great with me. But I'm assuming you're not going to let it in, so I wasn't going to try to get it in because I don't think that that's a dying declaration type of statement. So I'm stuck. So I would like the jurors to know that unfortunately he passed, and that the state stated that they would call him as a witness and subpoenaed him. And if the state has reasons that they didn't call him, that's fine. I understand I'm opening a door, but that's why I put it in writing. That's my motion.
All right. Well, I mean, if the state's case were over with, then that would be a different argument. But it is not as though the state's witness list has stayed in anything like any semblance of order during this trial. So, I mean, I don't think that if you can get a concession out of the state that they weren't going to call him even if he stayed alive, that would also be different. But I don't think that we've got that situation.
I understand the ruling.
All right.
Thank you, Your Honor.